versus CitiMortgage.
May it please the court, I'm Les Conklin. I represent Providence Lakes Master Association, Inc., the appellant in this case. This case comes to the court on a notice of appeal of a final judgment of foreclosure that was entered January 15, 2013. Your Honors, this case was a typical mortgage foreclosure case. It was filed September 29th, 2009. 2-count complaint. Mortgage foreclosure, count 1. Second count, lost note. No copy of the promissory notes attached to the complaint. I answer and assert affirmative defenses on behalf of Providence Lakes. I admit that they don't have the note. They don't possibly know where they can find the note. It's gone. I admit that. I deny that they have the right to bring this lawsuit, and I bring an affirmative defense alleging that they have no standing, didn't attach the note. They say in paragraph 5 of the complaint that they had the note via assignment. So,
didn't the judge ask you on the standing question at some point during this colloquy that you're only interested in one piece of the pie, and that's for the association fees, and that, in his mind, didn't relate to standing of who the note holder was, and issues like that? You had a monetary interest, not standing on the bank's ability to actually foreclose. Well, did you have that discussion? Because at one point he asked you, the court says, well, let's talk about that. What are your standing at this point? And you launch into this whole argument about McLean and cross-examination and opening the case, and you never actually addressed that. Am I wrong on that, or is there, at some point did you address that?
I thought I did. The point is, my client didn't ask to be hailed into court. We were served as a defendant. The complaint actually alleges that we had an interest in the lawsuit by virtue of, this is paragraph 14 of the complaint, Providence Lakes Master Association is joined because it may have a claim of some interest or lien in the subject property by virtue of a possible claim of lien or assessment. And then they proceed to talk about how they're suing under 718, the so-called protection.
Was there a cross-claim or an answer alleging, yes, we do have an interest and
yeah,
we're owed $1,000 or something like that?
No, did not file a cross-claim, did not file a counterclaim. My point being, though, we filed an answer to affirmative defenses. My argument, I thought, at court was, and I thought it was somewhere in the transcript, and that was, we're not a second-class defendant. There are defendants with some rights and no rights. We were hailed into court. Why don't we have all the constitutional rights as an association that anybody coming in? I wasn't claiming anything of the borrower. For example, although I claimed in the affirmative defenses a paragraph 22 defense, I never argued that at trial, but I did claim standing. And the point being, why, if my client's hailed as a defendant into court, why am I not able to raise whether the plaintiff has standing to bring this lawsuit? And certainly that's been defined by the 4th and the 2nd districts. I mean, I went through in the brief. The point is, what interest did they have to sue my client? They had to show that they had the original promissory note at the time, with endorsement, at the time they filed the lawsuit. Keep in mind, they don't find the note for 1,373 days. We're after pretrial and on the dawn of trial. Also, keep in mind, they filed a lost note affidavit. The copy of the promissory note attached to the lost note affidavit, no endorsement. The copy of the trial exhibit, which they provided to me late and under court order prior to the trial, no endorsement. But all of a sudden we find the note about 20 days prior to trial, and now it has an endorsement on it. And here's the interesting part. Mr. Sokoloff at trial asked for relief from admissions. I say, congratulations. I applaud that you were able to find the note after 1,373 days. He asked for relief from admission as to one admission, admission number 8. And, Your Honors,
Mr. Conklin, before you get too far, I just wanted to ask you a question about the endorsement on the note. What was the date of it?
No date on the endorsement. It was undated.
Undated endorsement.
Correct.
But
as they all practically are.
But their testimony, I believe, and their position was that we lost it, we found it, but we had it at the time of the lawsuit. Was that their position?
That was. However, I objected to Ms. Chamel's testimony in that she was asked after they had closed their case. This was when I moved for involuntary dismissal, saying you had 4 exhibits admitted into evidence. the note, the mortgage, the paragraph 22 letter, the notice of intent to foreclose, and the loan history, none of which showed when they took possession of the note or when the endorsement was put on the note. None of those. I will eat those exhibits in front of the court if you can find in those 4 exhibits anything that indicates when they came into possession of the note. And so Mr. Sokoloff, after he's rested and during my motion for involuntary dismissal, asks, Your Honor, can I redirect? And I say, wow, I haven't gotten cross yet. And Judge Padgett doesn't miss it, skip a beat. Judge Padgett says, are you moving to reopen your case? Yes, Your Honor. And he says, and the witness is no longer in the witness stand. She's sitting beside Mr. Sokoloff. When did CitiMortgage have this note? Oh, we had it before September 29th. I object again. Say this is hearsay. This is, and then we go into that long colloquy with Judge Padgett about, well, this is just a lady from CitiMortgage. If she, I seriously doubt she was there when the note came into CitiMortgage. She's just one of many employees. The point was, I must have argued every single one of the cases. I argued SAS. I argued Thompson, I argued Yost. I said, you can't have hearsay testimony with the business record coming in first. There was no business record as to when they took possession of the note. Let's get back, though, to the request for admissions, because that's important. If you look at, and it's transcript, it's R216, paragraph 17, this is the motion for relief from admissions made at trial. Paragraph 17 says, association will not be prejudiced if plaintiff is allowed to withdraw or amend response to admission number 8. You go to my request for admissions, I set them out in the brief, and they were several in length. Number 8 only deals with the original promissory note is lost or destroyed. All the other 11 requests for admissions were admitted. Keep in mind, I served the request for admissions with my answer and affirmative defenses. They didn't file a response. They filed a motion for extension of time to respond to make a reply to the affirmative defenses and to respond to the notice produced. They didn't ask for an extension of time as to the request for admissions. Judge Foster hears this and he goes ahead and includes it and says, because in their motion for relief, they don't attach a proposed copy of the responses. So Judge Foster says you have 30 days from the date, this order to file your response. Let's see, 561 days after the order, allowing them an extension of time to file responses to the request for admissions, they finally file a response. No additional motion for they never filed a motion for relief. The court heard that as part of their motion for extension as to the reply and the notice produced. So, no further motion for relief from admissions until trial, and he asks only for number 8. I read to the court number 6 and number 7. Plaintiff has no evidence that it had possession of the original promissory note on the date of filing the complaint. It's number 7. Plaintiff did not have possession of the original promissory note at the time it filed this complaint. My brief is replete with cases on no motion, no relief, no error. He asked never has filed a motion for relief during the course of the case. Day of trial, they have a motion for relief, and he asked for relief from one request for admission. Keep in mind, the record is also replete with the fact they don't have the note. A lost note affidavit, and it's complete as far as I looked in the filing cabinets, I looked in the file, I turned CitiMortgage upside down, I can't find the note. And the really comical part is the copy of the note attached has no endorsement on it. As I said, the trial exhibit that was provided to me pursuant to court order when they were late exchanging the trial exhibits, that has no endorsement on it. But we find the original note about 20 days before trial, and miraculously now it has an endorsement, undated. No evidence whatsoever. Additionally, Judge Padgett specifically said I could have cross-examination as to the amounts due and owing, and then he took that away.
What was the rationale for that? The only thing I can think of is in context he seemed to say it related to the standing issue and the amount in controversy, and you're not able to establish that you have any standing after the bank is paid off regarding a deficiency. I wasn't sure where he was going with that.
I have no idea either. I cited to him Spencer versus EMC Mortgage. I cited to him the Palacios case, which is out of the 2nd District.
Well, I think the way I read it, in addition to all that, was he said, well, the exhibits are in evidence, they documents, they speak for themselves, it's a mathematical computation. So in essence, these are unliquidated damages that can be established through the paperwork, whether it's hearsay or hearsay exception. I think that's what he was thinking.
Yes, but there was no computation of the interest. We all took it on face value. Ms. Chamel, CitiMortgage's sole witness, reads from the proposed final judgment over my objection. It's not a trial exhibit. It's prepared in anticipation of litigation, but she's reading from it as far as the interest. You think that it's liquidated and that's simple? I've won at least 3 trials where the witness said, I can calculate the interest from the witness stand, and when we took a recess, they couldn't. Here's the other thing. If you look at the loan history, and I think that was plaintiff's exhibit number 4 in evidence, the loan history starts 3 months. It misses 3 months of payments, so it starts in...
So you're saying it's not unliquidated damages? It's not liquidated
interest
damages?
is liquidated damages, but certainly the court costs, the attorney's fees, the other things that were put in there, I wasn't heard as to those at all, and you'll find no stipulation by me that I ever agreed to any of those.
But they've submitted affidavits.
To tell you the truth, I can't remember whether they did or not. My point being, I didn't stipulate that they could prove those by affidavit. And of course, I got no cross-examination. Back to the loan history. Loan history stops August of 2012. We tried this case January 15th of 2013. So we're missing 5 months. At the top end of the loan history, we're missing at least 3 months. The first payment in this case was due, I think it was, actually I don't remember, but the loan history, if you compare it to the note, they're missing the first 3 payments of the note. I certainly had something to ask Ms. Chamel about on the cross-examination. Here's the point though. I'm asking for the court to return this case and grant my motion for involuntary dismissal. I defy anybody to find in the record, other than Ms. Chamel's hearsay testimony that they had the note at the time they filed this lawsuit, anything in the record. As I say, everything in the record shows they didn't have it. Keep in mind, they would...
Let me ask you a question.
Sir.
You're seeking involuntary dismissal as to all parties or just your client?
As to all parties, Your Honor.
Even the parties that were defaulted?
If I show that there's no standing, why isn't it no standing as to all parties? You either have standing or you don't have standing. It's not standing as to the homeowners association and no standing as to the borrower.
I'm just trying to figure out your rationale as to the homeowner who defaulted gets a default. That proves liability. They have standing to contest damages. So why would we enter an involuntary dismissal on the entire case when liability had already been basically established?
Because...
As to them.
I understand.
You're not their lawyer.
But I'm saying standing is as to all people. The definition of standing is I have such an interest in the case that I can bring this suit. Keep in mind, I have 2 cases out of the 2nd District where I represented homeowners associations, and in both of those cases, this court found that the defendants had been defaulted in that case where I had won on standing. I was entitled to attorney's fees. That's Country Place, that's South Bay Lakes. So the point being, I have raised this before and raised this before this court. But you either have standing as to all parties, defaulted or not, or you don't have standing. The fact that one defendant wins and the other defendants are defaulted, I don't know how that's really pertinent. The point is, did they have the note with an endorsement in blank at the time they filed suit? Clearly, they did not. By the request for admissions, by the affidavit of lost note, by the filing of the complaint. Here's the interesting part. We go to trial. They don't even drop count 2 of the complaint. Everything that they had alleged and I answered, that was also an admission. That's the Carvel case that I cite in my brief. The point being, they didn't drop count 2. So now we're talking about BAC Funding Consortium and we're talking about Feltus. And that is, wow, we're proceeding to trial on a complaint that doesn't state a cause of action as a matter of law. Didn't move to amend, even at the close of their evidence, and certainly it would have been granted. They didn't move to amend their complaint to attach the note to the complaint. So they're proceeding on a complaint that has no note attached to it, and a viable count. They found the note, but they don't move to they don't move to even drop count 2. The proper method that this court has outlined in Feltus is you need to amend the complaint.
One of the
I'd like to reserve 5 minutes if I didn't mention it.
Okay, you're
Right on it?
timing, yes, sir.
Very good, thank you.
Good morning, Your Honors. Rhiannon Funk here on behalf of the Appellate. Thank you for your time this morning. So just as an initial matter of rebuttal, Mr. Conklin has stated that there was no evidence in the record of plaintiff standing, and I respectfully disagree. While he may contest the evidence that was presented as to the possession of the note on January 29th, 2009, which was about 8-9 months before the filing of the complaint, there were 2 other pieces of evidence that related to the standing and the equitable interest in this loan. There was a breach letter which was sent to the borrowers before the filing of the complaint. It was sent to the borrowers and it was sent by CitiMortgage. Additionally, there was a payment history that evidenced payments received by CitiMortgage from the borrowers. Those 2 pieces of equitable evidence would be sufficient for a court to find that this is in fact the proper party withstanding to bring this mortgage foreclosure action. So respectfully, I do disagree that we had failed to establish that there was in fact standing. While the evidence of the original note would be the best evidence, it is the better weight of the evidence at trial that should be compelling.
Did the judge actually say he didn't have standing?
No, in fact, that opposing counsel did not have,
Right.
that the HOA, no. He did indicate at times that he thought the standing was limited just to the right up to assessments. I do know that the association did address an additional right to redemption that they were claiming, though it is our position that in fact they did not hold that interest in the right of redemption, which is generally limited to the mortgagor or their successors or other mortgagees. So with that being said, again, my position is that this case is about 2 competing notions of standing: that of the plaintiff in this case, the appellee, and that of the association. We believe that through the evidence that was presented to the court that we have established standing based upon the borrower's own default and admission by default of their obligation under the mortgage and their default on the mortgage and their failure to cure that default.
Well, do you disagree he had standing to conduct cross-examination?
I think that he had standing to conduct cross-examination, but it should be limited very much to the scope of their standing in the lawsuit generally.
Okay, did the judge limit it to anything? Did he even allow 1 question?
He didn't ultimately at the end, but that was, I believe, based upon the sort of inquiry and discussion with counsel as to the scope of their interest. And so my position is that opposing counsel failed to proffer failed to answer the question, which was asked 3 times, what their standing was, with any discernible actual and real interest. There are conjectural and hypothetical interests, such as a lien interest, which was admitted at court that it was in fact already foreclosed and a third-party purchaser had taken the property, and also a conjectural interest in a right to redeem, but he cited no authority that would provide the homeowners association the right to redeem the property, and that was the party he was there to represent. Now, to have standing, a party must demonstrate a direct and articulable interest in the controversy, which will be affected.
Let me ask you a question before you run off that. He's representing the association. They have a lien for X dollars, whatever that amount was, and that it would anticipate to be paid off if, for example, the amount owed is less than the fair market value, where the sale could bring an excess judgment. He'd have money to get paid. So how would that not be an interest in the amount in controversy owed by the homeowner?
Essentially because that interest doesn't even vest until after the foreclosure judgment, and it's still hypothetical at that point. Moreover, actually, let me go here, if I may.
I mean, are you saying he would have to show that at the trial to establish the interest in the outcome that would have allowed him to cross-examine the figures in question?
I think that would have been very beneficial, and there would be a duty at least to proffer what questions would have been asked, what the expected result would be. There's ample case law on the right to cross-examination, and there is a duty to proffer to establish what that relevance would have been and what was denied him, and there was no proffer in this case.
Did you argue that in your brief?
Unfortunately, I did not. I did argue standing, and it's sort of related to that standing. I did do the notice of supplemental authority, which is related to the standing. I mean, it is essentially, he was asked 3 times what his standing was. The judge was trying to get to the relevance of what was going to be inquired upon, and without articulating the standing and without articulating what he was being denied, it's really not right for this court to review what might have, would have, could have, should have been done. Ultimately, and furthermore, the court does in fact note several times he doesn't believe that the association has brought any evidence to contradict what was being presented and what was admitted by default by the borrowers. So we have a third party of the contract, no privity to the contract, now seeking to attack the rights and duties of 2 third parties. And without bringing that to the court, without bringing the standing to the court's attention, and without proffering what relevance it would have had, it just fails to properly preserve the issue. Now, that brings me actually, that brings me to another issue, which is that in this case, the Homeowners Association has attempted to invoke all of the benefits of the mortgage contract without undertaking any of the obligations or burdens thereto. So with this being said, it is by allowing him to cross-examine the bank's witness as to the amounts due and owing because they have a conjectural right to redeem, or that the sale might have some impact on their right to collect assessments, you're essentially opening the door to virtually any party seeking to intervene and challenge the amounts due and owing.
Well, except for in his case, I thought I heard you say a conjectural right to redeem? He has an absolute right to redeem, doesn't he?
Well, I have researched this. I could not find a single case that offered the Homeowners Association a right to redeem when there is no claimed lien, and there was no lien alleged or claimed at trial or anywhere in this court.
So why were they named in the suit then?
Basically, there is a continuing possible lien that springs from the right of the Homeowners Association and a duty by statute to name them as to their rights to the safe harbor assessments, those statutory assessments.
Judge Padgett basically said to Mr. Conklin, if I remember from reading the transcript, he said, well, in this situation, your case is all about fees, right? And what you're telling me, there were no fees owed.
Correct.
So there was nothing owed.
And that can be discerned from the record because at page, let me pull up that page. It's in the record, I believe, page 21, lines 7 through 14. The HOA admits that the HOA has already foreclosed their lien. This is a third-party purchaser. They bid for it and bought it at the foreclosure sale of the HOA. So at that point, they've already satisfied their lien. It's in the record.
So they were joined as a party for a chain of title problem in the future, so they couldn't come in and file a claim and say we had no notice.
Yes.
Just like a tenant in possession has to be joined in the foreclosure, even though technically they're not on the note, they don't have an interest. So basically, the Homeowners Association didn't have a lien. Judge Padgett was wrong about that?
In fact, he was. The right and interest was
And
actually
that's why
right.
they didn't have a cross-claim or a counterclaim.
Right.
They had nothing, just
Well,
an answer denying the complaint?
That was, I mean, procedurally, this is a little bit outside of the record, but to satisfy the curiosity,
Well,
I
honestly,
yeah.
I'm not that curious. I don't want to put you in a pickle.
Okay.
Okay.
And so, now, lastly, I would like to go to the issue of, let's see here, basically the issue of the possession of the original note. We've already discussed the fact that the breach letter was in fact mailed by the appellee in this case. The payment history shows payments by the borrower. Those are circumstantial pieces of evidence. There are cases that support that notion. Johns v. Gilliam and WM Specialty Mortgage v. Salomon are both cases that go to the point that it is, even without an assignment of mortgage, even just a passing of the interest in equity would entitle a party to a mortgage foreclosure here. So with that being in the record, there was a hearsay objection lodged, but it's noteworthy here that there was no voir dire of the witness. There was no attempt to disqualify the witness as a records custodian. And it was at the close of plaintiff's evidence that the cross-examination was sought. But the evidence was already into the record, and there was no disqualification. Now, At that point, I think I have addressed most of the issues that I wanted to cover, but if Your Honors have any other further questions for me in relation to this matter.
No, thank you.
Thank you.
Thank you.
While realizing I only have 5 minutes, I'll go quickly to address the first issue that she raised. And, oh, there's other evidence in the record, a default letter and the loan history. Well, the loan history did precede the filing of the complaint, but in the two affidavits that they filed with the court, the affidavit as to the lost note and as to the affidavit as to...
Before you argue the substantive issue of that nature, could you just touch upon this right of redemption?
Oh, certainly.
That I think flows from there being some sort of a lien to be redeemed?
No, it has to do with the recordation, really, of the declaration of the homeowners association.
Well, I can understand why you would join as a technical precaution, but I think I heard her say the association didn't allege an amount actually owed.
We did not, but she's now attempting to get in evidence, which I've already had stricken by this court when she did the notice of judicial default. The point being, that's not before the court. They alleged literally in the complaint.
I mean, did you or did you not have a right of redemption on behalf
I
of
do.
your client? What would you
And it
be?
isn't just through the claim of lien, it's through section 45.0315.
Is it a speculative right if there was no money owed? Or is it an absolute right that still applies and gives you the standing to argue amount in controversy?
Even Ms. Funk has conceded that they sue us because it's like a mechanic's lien during that 90-day safe harbor,
But I mean, it's almost like you're getting upset that your client was sued, but your client wasn't sued for wrongdoing, was joined as a technical party.
What I'm upset about is that my client's joined as a defendant, and then we don't get rights, according to the lower court, to raise issues of standing, whether plaintiff has the note when they file suit. They had no right to sue my client if they didn't have standing. They had no right to sue anybody if they didn't have standing. That's, there are three legs that every lawsuit stands on when it starts: venue, jurisdiction, standing. What right do you have to come before the court and ask for relief? And the point is, you have to. This court has ruled on a lot of occasions, and most recently, I think in Kelsey, you must hold the note at the time that you filed the suit with the blank endorsement. Feltus says you have to not only show when you got the note, or how you got the note, but when you got the note. And in this instance, when was that endorsement put on? As I was going to say, she says, well, there's evidence in the record. We have a loan history and a letter. The two affidavits previously filed in this case says CitiMortgage is the servicer for this loan. So the fact that they're servicing the loan doesn't mean that they had that note. And in fact, when they started the case, they said they didn't have the note. The other part, though, is, and I was going to read section 45.0315, right of redemption at any time before the latter of the filing the certificate of sale. It says, the mortgagor or the holder of any subordinate interest may cure the indebtedness. The point is, homeowners association, condo associations always have that right of redemption by the recording of the declaration of condominium, by recording the declaration. They sue us even if there are no liens outstanding or filed of record, because it may become standing during the course of the litigation. Of course, this case took 4.25 years, so I presume that at some point there might have been outstanding assessments paid, and so that's the point. So, the right of redemption, it's worthless if in fact you don't have the precise amount due and owing. This court in the Palacios case, cited in my brief, says even third-party bidders have the right to know the precise amount due and owing so they can make a bid. So even non-parties to the proceeding have a right to know what the full amount is. Right of redemption, by the way, is also by common law, and I've cited several cases in my brief as to the common law right of redemption prior to the legislature adopting 45.0315. So the point being, no, there's still no evidence. That letter of default to the borrower, that doesn't say anything about them holding the note and mortgage. They were the servicer. To the loan history, no, that's not evidence of that. The evidence was when I brought up to the court, and the court knew that I won at that point. When I said, they closed their case, and I said, Mr. Sokoloff promised at the beginning that he would put on evidence as to standing. They put on no evidence. And that's when Judge Padgett said, well, when Mr. Sokoloff jumps up, oh, can I have redirect? And I said, well, I haven't gotten cross yet. And
Sir, you're at your 5 minutes.
thank you very much.
Thank you.
I appreciate it.
All right, our next case this morning, Bozak versus Albert and Wares.